So this brings us to directors and officer duties, because directors and officers share duties, right? They are both in the fiduciary status with regard to the company. So the two duties are duty of care and the duty of loyalty. We know we kind of strung throughout a bunch of themes throughout the semester. Care and loyalty have popped up, definitely in the partnership arena, but we began with similar concepts in the agency arena as well. So we'll start with the duty of care, right? In this case, it is defined as in two ways: the responsibility to make reasonably informed decisions. That means to obtain and utilize available, necessary information, right? And that's based on the facts and circumstances. How do we know? Because we have to make reasonably informed decisions, and that means that we have to take into account everything that we become aware of in the fact pattern that determines whether that was a reasonable amount of information to collect. And that encompasses any ambiguities as well as anything, right? So in order to weigh that, that's not always easy, but think of it like this. Let's say that my company is taking over another company, and I'm a CEO of that company, and in the process of investigating the company in order to make the purchase, I fail to take a crucial step in due diligence, right? Not intentionally, but I was negligently negligently failed to accomplish a certain step within the due diligence process. I breached the duty of care, right? And so that's a duty that I owe to the company, and I can be liable for that breach of duty, right? Also, to exercise reasonable supervision of delegated work, and this includes agency principles, right? But it also may include anything that you delegate, right? But just to be aware, the further afield the delegated work is from what it is that is my primary kind of area of knowledge and expertise, the less supervisory authority I can be expected to exercise. But in the case of if my business is flipping burgers, right, and I'm a director of that company, then at the director level, I need to, at the very least, make sure that we have policies in place that make sure that the burgers that get delivered are quality burgers that are delivered safely to the company and which are fit for their intended use, consumption as food, right? And as an officer, I need to make sure that, for my part, because I'm working for the company to execute the management, that I hire employees who understand those guidelines for delivering that safe, healthy, fit for use burger, right? And then as an employee, obviously, I'm responsible for actually delivering the. Hey, yes, I'm. And so, as said, just as I guess the point was that at each level, each party is responsible for carefully delivering that product, right? Whatever it is that would be within that party's responsibilities in the normal course of their duties, right? For directors, it may be one thing. For officers, it'll be another, right? And obviously, they're supervising employees who, as agents, have a duty to perform, right? So it kind of passes some of that on to them to do their work carefully. Now, judging this reasonableness standard is kind of tricky. The business judgment rule that you may recall from previous discussion helps to sort some of it out, right? So this suggests that there won't be directors or officers liability in the following cases, right? This is the case where the director or officer, as the case may be, one, took reasonable steps to become informed. Second, had a rational basis for their decision, which means they connected what they discovered when they became reasonably informed to the reason that they made the decision that they made. right? So they had a rational basis for their decision. And third, that they don't have a conflict of interest, which we will talk about shortly when we talk about the duty of loyalty. If that duty of loyalty principle is not violated here, then and these other two conditions are met, then the business judgment rule will generally protect you from personal liability for actions taken as a director or an officer. The duty of loyalty is interesting, right? Again, we talked about this in a number of capacities, including throughout agency and in regard to partnership. And here again, it comes up with respect to directors and officers. The duty of loyalty can be described as a fiduciary duty to place the welfare of the company above one's own welfare, right? You are not only acting by, for, or instead of the principal as an agent, you are acting in their best interest, even if that best interest, puts them in a better place than where you are, right? So here we can't use confidential information. There's two defining principles here at the top. You can't use confidential information for your own personal benefit as opposed to for the company's benefit. And you have a general responsibility to avoid self-dealing. And when I say self-dealing here, I'm talking about a particular type of transaction, self-interested transaction, right? Certainly related businesses do business together all the time, right? Like I may be a director of one company, but my family may own another company, and that company may supply this company that I'm sitting as a director on. There's nothing generally wrong with that. We're talking about a particular type of transaction. When we deal with the Pepsi-Cola case in a second, you'll see what I'm talking about. All right, but the times when this becomes a problem are sort of outlined here in these bullet points. Number one, competing with the company, right, is generally a no-no, particularly where the competition, you wouldn't find people sort of pre-existing competitors agreeing to serve on one another's boards, right? Usurping a corporate opportunity. Oh, you're going to really enjoy this Pepsi-Cola case. Any conflict of interest, what's known as insider trading, which we've talked about a bit, and transactions which may be harmful to shareholders and could cause a shareholder lawsuit to arise, and certain types of changes in control. Although, as we'll see, changes in control are natural occurrences within the life cycle of a business. At some points, they can be abusive. So that's, if it's a duty of loyalty case, it can come up in that sense. All right. So this brings us to a discussion of Guth versus Loft Incorporated. Guth versus Loft Incorporated. And throughout the first part of the 20th century, there were these companies, the Loft Candy Co., the Loft Candy Company, the Grace Company, and the Pepsi Cola Bottling Company. All right. This is a 1939 case, and although we don't have any lofts around in the current day, during the 1920s, Loft Candy Company, which was based in Long Island City, New York, was a publicly held company with $13 million in revenues, and it was a restaurant and candy chain. All right, they manufactured their own candies and their own beverages and what have you. One of their suppliers was the Coca-Cola Company, as it turns out. And it also happens that this gentleman here, Charles Guth, became the CEO of Loft Candy Company, right? He became the CEO of Loft Candy Company at a time of great contention within that company. But he became the president and CEO of Loft Candy Company, and his family also happened to own the Grace Company, right? So in his capacity as an agent of Loft Candy Company, Mr. Guth became disappointed with the high prices that Coca-Cola was charging. And so he made the choice to buy with a partner the Pepsi Cola company, all right? They decided to buy Pepsi Cola, and then they began supplying the Loft Candy Company with the syrup that they used to make the. Sorry about that. How you doing? However, unbeknownst to the to Loft Candy Company, Mr. Guth had acquired, was running the operations. He and his partner were running the operations of Pepsi Cola Company using Loft Candy Company's credit and its employees and even some of its facilities, right? In addition, Mr. Loft created quite favorable trade arrangement between Loft Candy Company and the Pepsi Cola Company that he now owned. One that extended generous credit to Pepsi Cola in Pepsi Cola's favor for the services that Loft Candy Company was providing to Pepsi Cola. 40 months. And similar in relation to monies that would have to be paid for in any situation where monies would have to be paid by Pepsi Cola to Loft. He also created a favorable arrangement to smooth out the details between Loft and Pepsi Cola Company, right? He basically used Loft's resources in his capacity as CEO to prop up the operations, the early operations of the Pepsi Cola Company, right? Of course, at some point, this became contentious. Loft, Grace, which owns Pepsi Co. Company, and obviously Guth, who is a shareholder of Grace, and in that capacity also a owner of the PepsiCo company, are sued, and particularly Guth is sued for a breach of the duty of loyalty. All right, so you can see that. I can kind of get to the text of it, and then we can kind of get to our question for this segment. All right, so in the case, Guth loses all of his stock, and as well as damages. Right, it's transferred basically over to the Loft Candy Company, and the court notes in the appeal, because obviously he doesn't want to lose this opportunity that he created, that he basically took from Loft. Corporate officers and directors are not permitted to use their position of trust and confidence to further their private interests. They stand in a fiduciary relation to the corporation and its stockholders, a public policy existing through the years and derived from a profound knowledge of human characteristics and motives, has established a rule that demands of a corporate officer or director peremptorily, as in completely and not open for debate, and inexorably, which is unavoidably, the most scrupulous observance of his duty, not only affirmatively to protect the interests of the corporation committed to his charge, but also to refrain from doing anything that would work injury to the corporation. The rule that requires an undivided and unselfish loyalty to the corporation demands that there shall be no conflict between duty and self-interest. No conflict between duty and self-interest. The appellants contend that no conflict of interest between Guth and Loft resulted from his acquirement and exploitation of the Pepsi Cola opportunity, and that the acquisition did not place Guth in competition with Loft. In this case, however, Guth was Loft, and Guth was Pepsi. He absolutely controlled Loft. His authority over Pepsi was supreme. What he offered as Pepsi, he could effectively accept as Loft, right? To the extent that this places Loft in a less advantageous position vis-a-vis Pepsi or vis-a-vis the market, right? Or to the extent that it is detrimental to their interests, then Guth is essentially in breach of his duty of loyalty. So the Delaware Supreme Court in this case, in this landmark case, which is Guth v. Loft, which is 34.1 of your cases, all right, they upheld the judgment of the lower court. They were convinced that the opportunity to acquire Pepsi-Cola trademark and formula, goodwill and business, belonged to Loft Candy Company, and that Guft, as its leader, had no right to appropriate the opportunity for itself. This breaks the inquiry into two effective parts, right? Whether the opportunity was reasonably related to the company's business and whether the company was financially able. I've hybridized this, right, in a third point that says any interest or expectancy in the venture will cause there to be a breach in the duty of loyalty. If the company did not have any legitimate interest or expectancy in the venture, then there's no duty of loyalty needed and the executive is free to pursue their own interests. Here's the question that will appear below this prompt. Suppose that Loft's board of directors had approved Pepsi-Cola's use of its personnel and equipment. Would this decision have been different? In order to do this, answer this question, you'll simply have to review the case, right, that I just went over, Guth v. Loft, 23, Delaware Chancery Court, 255 from 1939, and then answer that question. Suppose that Loft's board of directors had approved Pepsi-Cola's use of its personnel and equipment. Would the decision have been different? Discuss. All right, see you guys next time.